If you're receiving threatening or harassing phone calls from creditors or collection agencies, then keep watching. The following is a recording of a live interview with Ari Marcus, an attorney and litigator with Marcis Zellman. Now, in this interview, Ari reveals how he leverages the Telephone Consumer Protection Act and Fair Debt Collection Practices Act to not only remove collections from clients' credit reports, but also how he's able to obtain hundreds of thousands of dollars in awards for these same clients. On a side note, shortly after this video was recorded, I myself began receiving harassing phone calls from a creditor 3 times a day for 30 days straight. Armed with the information I learned in this interview, I was able to properly document the violations, and I retained Ari to help me fight them. After a few months, the creditor settled for $20,000. So if you like money and you want to know how to fight back when creditors and collection agencies come calling, then grab a pen and start taking notes. But before you do, please click the subscribe button now so you can stay on top of the most cutting-edge credit repair strategies today as we release future videos like this one. Enjoy. This is Brian Diaz with howtofixmycredit.com. Welcome to the FDCPA and TCPA Violations Explained. My guest speaker, Ari Marcus from Marcis Zellman. Excuse me. All right. Marcus, thanks so much for joining us today.
Yes, thanks for having me. I'm very excited to be here.
So a little bit about yourself. I mean, I have your bio up on the screen for everyone to see. You're a graduate of Brooklyn Law School, founding member of Marcis Zellman LLC, offices in New Jersey and New York, and your practice is mainly solely based on litigation, defending people against TCPA and FDCPA violations. Is that right?
That's right. So I started my firm in 2010. A couple years ago, we brought in a partner, so we made it Marcis Zellman. The only laws we practice in are consumer-related laws, and we focus on FDCPA and TCPA. So we're representing consumers against banks, debt collectors, credit agencies, any big companies.
Just out of curiosity, what made you go in that direction?
Well, when I started out, it was a general practice firm. We did real estate, driving tickets, you name it. And we had a couple clients come to us with problems with debt collectors. I read up on the law. And because it's such a niche, once we started doing that, the referrals started coming in, and really within a couple of months, we decided to scrap everything else and just focus on these laws.
Now, when you're defending someone, do you have to be located in the same state as them, or you can defend anybody in any state?
Sure. So we don't defend consumers. So what we do is we sue the debt collectors. So we're representing them. We don't help out consumers who are getting sued. It's a little bit different, but we have a national firm at this point. So we have local counsel in almost every state. So we get clients all over the country.
Oh, okay. So, I mean, graduating from 2010 to 2018, already a nationwide company, must be a good niche.
Yes, it's a really good niche. There's not too many attorneys doing it, and we've already made a name for ourselves. So we get clients from all over.
Awesome. All right. If we could, I'd like to kind of dive into really defining the FDCPA and the TCPA, so that anyone listening can have an understanding of what laws you are referencing, so that we start talking about violations, they can kind of put everything together in the head.
Perfect.
If you could we start out with the FDCPA?
Sure. So the FDCPA stands for the Fair Debt Collection Practice Act. It was enacted in 1977. It is what it says it is. It's a law that's there to protect consumers against debt collectors. It prohibits, various type of conducts, things like misleading consumers, lying to consumers, false threats. There's also laws that debt collectors have to notify consumers of certain rights they have. And if they violate any of those rules, consumers are entitled to compensation. In addition, because Congress understood that people getting collection letters may not be in the best position to pay an attorney or afford an attorney, it's what's called a fee shifting statute. So the debt collector has to pay all the fees and all of the costs at the end of the case. So we don't charge any money to our clients to take on any FDCPA case.
Okay, awesome. So who falls under the FDCPA? Is it only debt collectors?
Yes, so good question. First off, the FDCPA only applies to consumers. So if you have any underlying debt that started with a business debt, that the FDCPA would not apply. So if your business opened a credit card, you went into default, now American Express is coming after you personally, that debt was originated as a business debt, so it would not apply under the FDCPA. And on the other side, FDCPA only applies to debt collectors or debt buyers. So it has to be a third party who took over an account once it was in default. The difference is there are companies called billing companies. So for example, if you lend someone money and before it goes into default, you hire a third party, and this is what a lot of mortgages do. They hire a servicer.
Right.
That servicer would not be a debt collector under the FDCPA. But if they hand it over to a servicer after you're in default, and that really depends on what your contract says. So sometimes it says if you don't pay for 90 days, you're in default, sometimes 120 days. But after that time, if it gets passed over to any third party, whether it be a big bank, whether it be a mortgage servicer, or your typical Midland funding portfolio debt collector, they would have to now comply with the FDCPA.
Okay, so a question I get all the time is, let's say it's the collection department from ABC Bank. That wouldn't be considered a collection agency, that, and for the FDCPA is concerned, that would just be a creditor collecting for themselves.
Correct. So the FDCPA wouldn't apply. Now there's some states like Florida and California and some other ones that have their state FDCPA that may apply to the billing department, but the federal law, the FDCPA, which applies throughout the country, they would not have to comply with it.
Okay, very cool. And now the TCPA, Telephone Consumers Protection Act.
So the TCPA is a lot more exciting. There's a lot bigger cases, bigger class actions. We are taking a big hit under the TCPA, which I'll explain later. But generally what the TCPA is there, what it states is no company can call your cell phone with a machine unless they have your permission. It also applies to text messages. It also applies to junk faxes, but we'll focus on phone calls because that's the majority of cases. And what it means by permission is if they're calling for a solicitation purpose, so American Express wants to advertise or your solar company wants to advertise, you need to have signed something that said specifically that you're giving them permission to call you with a machine. If they're calling for debt collection purposes, which is a little bit different, as long as you provided them with your phone number, you gave them permission. However, in both scenarios, the FCC stated that you can revoke consent in any reasonable manner. So if you wrote them a letter and said, stop calling me, or you told them over the phone in most cases, stop calling me, then they're no longer allowed to call you. And the liability is pretty severe. They have to pay you $500 to $1,500 per call. So 100 calls, you're talking about $50,000 to $150,000. And it's not uncommon for companies like Chase, Citi, Synchrony Bank, these big banks to call consumers 5 or 6 times a day. So a couple months of these unwanted, annoying calls could end up being a huge recovery if you win in litigation.
Oh, awesome. Actually, I have something going on with that right now. I was going to save it for later. So you had something exciting for you to discuss with me in a little bit. So before we get to that, though, if we could cover some of the more common violations, so that people, as I tell people all the time, becoming familiar with the violations, it opens up a whole new world to you, because especially in credit repair, if you're looking at a credit report, you could be looking at a dozen violations just because you don't know how to recognize them. You don't know how, that you actually have rights that protect you in those situations. So some of the more common violations that people could come across, that, they know it's the right time to call you, that they're in a situation where you could get help.
Well, in addition, the law is always evolving. There's always new case law coming out. There's always new attorneys that are pushing the envelope and finding that new violation. And those are exciting times when someone wins a big case like that, because then you could go back and find all these violations that you may not have known was a violation or not. So what I tell usually the credit repair companies, especially initially, is if you hook up with a consumer attorney, someone that you trust, someone that you like, send every collection letter you get, send every communication. If your clients are getting voicemails, send that over to an attorney. They'll review it for you, and that's the best way to start learning and picking up these violations. But some of the common violations we see are, I see some of them are up on the on the PowerPoint. Collection agencies contacting third parties and notifying them that you owe a debt. Collection agencies contacting you either over the phone, in a voicemail, in a letter, and not identifying themselves or stating that they're contacting you from a debt collector. That's a violation. Some other violations include when they send you that initial dunning letter. And this is where we find most of our violations that we pick up. On that first initial dunning letter, a debt collector has to notify you of 5 things. They have to notify you who the current creditor is, and we find all the time where they only mention the original creditor, not the current creditor. They'll write original creditor T-Mobile or original creditor Chase, and they don't tell you whether Chase still has the debt or whether the debt was sold to someone else or whether a third party now owns it. They have to tell you how much you owe in the debt. And if interest is accruing and they don't mention that interest is accruing, that's a violation. Because if the letter is dated January 1st, it says you owe $100, but interest is accruing. By the time you receive the letter, you don't owe 100 anymore. You owe 100, whatever interest was accrued. So if you know interest is accruing, the letter doesn't say interest is accruing or doesn't clearly identify that, that's a violation. They also have to notify you of a statement you've probably read hundreds of times. It's something like, unless you, the consumer, dispute the debt within 30 days of receiving this notice, we will assume it's valid. If you dispute it in writing, we'll send you verification. If you request in writing, we'll tell you who the name and address of the original creditor is. We find that for whatever reason, debt collectors mess up that statement all the time. And if you've seen that paragraph over and over again, a lot of times your eyes just overlook it. But if you read it carefully, a lot of times they miss a word, they miss a phrase, they miss something that they had to notify a consumer. So we find a lot of those violations as well.
I'm curious how that happens. I mean, if you're a collection agency, don't you have it written perfectly one time, and was somebody going in and editing it each time they get a new client? How does that happen?
Yeah, it is pretty shocking. What we find is a lot of the debt collectors use different letter vendors, so they hire third parties to actually create the template and send out the letters, and the letter vendors will mess it up a lot. I couldn't really explain to you. And it's possible because it's such a niche, there's not a lot of attorneys doing it, that they've been sending the same letter out for 10 years, nobody ever told them anything. And that's not uncommon. We'll sue a debt collector or a law firm who's collecting a debt, so they are a debt collector, and their first impression is they'll call me up and say, I've been sending the same letter out for 10 years, nobody ever said anything, or I got this letter out of a continuing legal education book, and therefore it has to be compliant. I guess nobody was picking up on it, so they've just been doing it over and over again.
Right.
But
do you actually have like a cheat sheet that if, like a sample letter showing everything that should be on it, how it should be worded, that someone who received the collection letter could compare it against?
I don't. I mean, if a debt collector was ever to hire me, I would never work for them. But if they were to hire me, I would tell them on that initial letter, it should be as vanilla as possible. You just want to tell them, this is what you owe, this is who the current creditor is, and just state that one paragraph that they're legally compliant to say, and that would be the entire letter. But the things I look at is, when I see a letter, my first glance is, okay, let's look at, do they tell you who the current creditor is? Great. Do they tell you the amount due? Okay. Now I'm looking, does it have a phrase in there about interest? And if it doesn't, I make sure to ask the consumer if interest is accruing, or we wait till the second letter comes in to see if the balance increased or not. Then I look at that paragraph that I was mentioning before, and I read it carefully. If you want to see how the paragraph should look, you should just look at the FDCPA. You could pull it up online. The statute, that part of the statute is 1692G, and you could just, it's really simple. Just compare the way the law writes it and compare the way the debt collector puts it in their letter. And if there's any differences, there's a good chance that you'll find a violation. Other things I look at are, obviously they have to have what's called the mini Miranda. That's the notice that this is an attempt to collect the debt. Any information can be used for that purpose, so I look for that.
It's obvious to you. I'm breaking this all down. When we're done with this, I'm going to put together a cheat sheet that's going to have step by step. When they're looking at the collection letter, step by step, everything to look for. And at the bottom is going to say if any one of these things is missing, or it's not not as it's stated as provided. That,
sure.
With your contact information, to contact you directly.
Yes, and like I said, a lot of this stuff is easy to me. I get it. I do it all the time. I know nothing about credit repair, so if anyone asked me a credit repair question, it would be science to me, rocket science. But really, the best thing to do is oversend if you find an attorney you like, and they'll work with you and they'll show you what they found, and then the next time you'll be able to find it on your own. And part of the reason is, like I said earlier, the law is always evolving. We'll find a new case law comes out, or we'll push a case that we may not have pushed in the past. We got a good decision. Now we'll go back and look at all the letters to see if the same thing happened.
Okay. I just want to attack some of these things you have on here, because you kind of jumped around a little bit, which is awesome.
Yes.
I liked all the stuff that you were throwing out there. I just want to make sure that people understand, because like you said, to you, this is, common sense, but
yep.
for anyone else, myself included, might not be clear exactly by, what exactly you're intending. So notifying a third party that a consumer owes a debt. So if I'm sitting with a client, for example, if I were to call the collection agency and start talking to the representative there about my client's case, and I don't first provide them with like a power of attorney, that would be something that fits that criteria, right?
Okay, so let me understand your example. You call a debt collector and you say, I'm calling on behalf of somebody else?
Yep.
And they don't ask you for a power of attorney or anything like that?
Right, and they start sharing information, private information from the client.
Right, that would be a violation.
Okay. More common, go ahead, that's what I was looking for.
Yeah, more common is we'll find debt collectors calling aunts, uncles, cousins, or calling even the consumer's house and leaving a voicemail, and the mother overhears it or a friend overhears it. Those are more common third-party violations we find.
So really, them leaving any type of voicemail in regards to that it's a collection in general, if it's recorded, then that's kind of a bad thing, right? That's
They run the risk of violating the law. If a client comes to me and says, look, I was home, or I live with my mom, she heard a voicemail, she knows I owe money now, that's a violation we would sue on every day.
Okay. Communicating with the consumer is represented by an attorney. So I retain you and you send them a letter saying, hey, I represent them now. If they make any type of attempt to contact me directly from that point further,
yes,
that would fit that criteria. Okay.
Yes, so that's another common violation. A lot of times consumers come to us with collection letters and they may not have a violation, or I may want to follow up to see if interest is accruing, anything like that. I'll send a letter out, and I wouldn't say a huge percentage, but maybe 5-10% of the time they'll respond and send the verification letter directly to the consumer. And if they do that, clearly they know, or they should know, that consumers represented, and then we'll have a case.
Okay. Communicating with the consumer for the purposes of harassing. And that's when they're just being overly aggressive and not letting up, like calling 3, 4, 5 times a day?
Sure. So the way it sounds like you're reading it is the first 2 violations were under what's called 1692C, as in cat. And if you want, I could go through the rest of the violations in there. The FDCPA is not very long. I could go through the whole thing right now and give you the common violations. So C deals with communications. So you dealt with communications with a third party. You also dealt with communications with a represented attorney. The third example are communicating with consumers at an inconvenient time. And this is a great violation. So what everyone doesn't know, or what, if you read Google and you're reading like a summary of the FDCPA, everyone assumes that violation means that a debt collector can't communicate with you before 8 a.m. or after 9 p.m. And that's because the FDCPA makes that as the example, or it's a presumption that during those times it would be inconvenient. But in reality, what's inconvenient for you is subjective. So if you tell a debt collector, look, I work from 9 a.m. to 5 p.m., so contacting me during that time is inconvenient, and they contact you during that time, that's a violation. So we have a lot of consumers who do that, and they end up getting a violation that way.
Out of curiosity, how do you prove something like that? That they were notified that that time was inconvenient? Does it have to be in writing?
Well, how do I? So it's tough. I don't want to talk about recording phone calls. In New Jersey, it's what's called a one-party consent state. So consumers can record a call without notifying the person on the other end. Some states are not like that, so it's important to look at your state law. But if we have a consumer in New Jersey, we'll notify them that they can record phone calls, and that's one way of proving it. Two, we have a lot of consumers who have no idea how to record a call and they don't feel comfortable with that. We just tell them, if you do it, just try and jot it down somewhere. Typically, if you're writing down as the call's going on, that's an accurate record that the court will accept. And then once we file suit, most debt collectors, especially the big ones, have recordings of all the calls. So we'll end up getting the call that way.
Right. Okay. Good point.
And then the last point in communication is, if you write to a debt collector, one of two things. Either you tell a debt collector, don't contact me anymore, or you tell a debt collector that you have no intention of paying them. Either one, they are not allowed to contact you anymore. So we have a lot of consumers who don't feel they owe a debt, whether it's a medical debt, they feel insurance should have covered it. And they'll write the debt collector and say, I'm not paying this, my insurance should have paid it. If the debt collector contacts the consumer at all after that, it would be a violation.
Okay.
And then that brings me to what you were saying. 1692D is the section about harassment. And these are more uncommon today. You're not going to have most legitimate debt collectors violate this part of the statute. But on occasion, we'll find a new guy or a shady company that does. And harassment would be calling nonstop, just over and over again, calling someone's office just for the purpose of annoying them, showing up to someone's house, things like that. I mean, those are, again, more uncommon, but it happens. Part of this statute also prevents debt collectors from publicizing that you owe money. And we actually had a case recently against a debt collector who sent a letter to our client. On the letter, it said something like, how would it feel if everyone in your church and in your community and in your schools knows you owe a debt? Wow. We created a website where we put your name and the amount you owe on it. And we're going to send this to all the bulletins to everyone in your area. And they actually did have a website. It was like a Google Sheets, and it listed just a bunch of people and the amount they owed. And we sued them for it. And they did end up paying the consumer a lot of money, and ended up shutting down. So it happens, but it's not more on the common side of the violations. And those are things that everyone can pick up. I mean, if a debt collector is harassing you, you should get the feel right away that something wrong is going on. And if it's happening to one of your clients, and you should immediately talk to an attorney.
Okay. All right. So making false, deceptive, or misleading claim representations.
Great. So now you're on 1692E. 1692E is your most general part of the statute, so it's the one we use most. It prevents any false, deceptive, or misleading representations. So if a debt collector says, if you don't pay within 30 days, you're going to be sued, and you don't get sued in 30 days, that's a violation. If a debt collector threatens to credit report and they have no intention of credit reporting, that's another violation. If a debt collector says that interest may accrue if you don't pay and they had no legal right to charge interest, that's another false, misleading representation. So any type of representation like that, any threat to do something that they had no intention of doing, if they threaten to communicate, if they threaten to wage garnish, if they do anything like that and they had no intention of doing it, and you know they have no intention if they give you a timeline and the timeline passes and it didn't happen.
Okay,
or,
that was my next question.
Right, or if they threaten to sue or credit report and it's 7 or 8 years old and they no longer can sue or credit report, whatever the statute of limitations is, if there's any language in there that's sort of misleading and it even implies that there's a chance of you being sued, that could be a problem. If you get a letter from a lawyer and it has that feel like, hey, if I don't pay, I may be sued, and maybe your client's in New York and the letter is from a lawyer in California who can't sue in New York, that's another, in our opinion, a misleading representation.
Okay. All right. So skipping down, so false threats, pretty much the same thing. I would guess.
Yeah,
right?
false threats. So we have a case against Portfolio right now. We just won a couple days ago. What Portfolio was doing was they were sending a letter out, and it's called their LL1 letter. So it's like their first letter, and it says on it, account transferred to legal department, and it has all these threats in there. Hey, we're willing to settle for you, but you only have 30 days, and if you don't settle in 30 days, we'll take you to court. Or they use the word, we may take you to court. And all these things will happen to you. And then in day 31, they would send out a second letter called LL2, and it'd be like, hey, we're giving you another attempt before we sue you. And what we found out is that they were doing this to everyone. So that first letter, that initial letter which said, if you don't pay within 30 days, you may be sued, we found out they had no intention of suing. So we argued it's a false threat of litigation, and we just won that case.
Nice. Makes sense.
Yeah, so you see it even with the big guys. Portfolio is one of the biggest guys. I'm just trying to think of other cases we have. I mean, again, the statute of limitation ones, you have to know a little bit more. You have to know how long that is in your state. So statute of limitations means how long a company has to sue you. Usually that's calculated from the date of last payment. In New Jersey, it's 6 years. In Rhode Island, it's 10 years. In Delaware, it's 3 years. So it varies where you live. So we try and get that information from our clients when they're getting letters in. And if they don't have it, we'll send a dispute letter in, and we'll get it from the debt collector. So we'll find out how old the debt was. Is there any implication in the letter that the client could be sued? There's been some case law recently that said that if a debt collector uses the word settle, and we understand settle to mean pay less than the full amount, but consumers also hear the word settle and they think of lawsuit. So you see a commercial on TV, it says, did you take a certain drug, you may be entitled to a settlement. And everyone understand that means you're legally allowed to go to court and get some money. Or, you know, Donald Trump just settled his Trump University case. We understand settled meant that he was being sued and now he's not being sued anymore. So they connect the word settle and lawsuits. And because of that, a lot of courts hold that if they use the word settle on a letter that's past the statute of limitations, that may be a violation under this 1692E.
Okay. So with these cases that you win, you have to let me know about this. I probably see like 40 or 50 credit reports every day from Portfolio. I might have like a dozen more for you.
Yes.
You have to let me know about these things.
Yeah, and again, I'm happy to send any case law over. We see new cases as they come in and decisions as they come down all the time. But if you're in the credit repair business, it's hard for you to read up on all FDCPA litigation and read up on all the credit repair stuff because there's new stuff happening all the time.
Right. Yeah, but something like that's relevant.
Oh yeah.
Very relevant. Yeah. So I have to go through my files for you.
Yeah. So just the last point, 1692E is also the part of the statute that says, and it would be E11, that a debt collector has to, in all communications, tell you that the communication is coming from a debt collector.
Okay. One thing that I think most people aren't aware of is the whole logo on the envelope thing as well.
Yes. So the next part of the statute is 1692F, which prohibits unfair or unconscionable means of collecting a debt. So part of that part of the statute is that a debt collector cannot put anything on the envelope besides the debt collector's name and your name and address. And if the debt collector's name says the word collections in it, that may be a problem also, because obviously the envelope is visible to anyone who sees it, the mailman, and that would be a way of communicating to a third party.
Right.
So We've seen cases where debt collectors use logos, and we had one that used a logo of a man holding another man upside down, and like change was coming out of him, a little cartoon. So that was held in violation.
Yeah, I think.
Yeah, we had one where it said like important tax information enclosed, and the consumer opened it and it was just a collection letter. So that would be another violation. And then what was big by us in New Jersey, although the rest of the courts around the country just disagreed, was if they put the account number that was visible through the glassine window. So they'd have the mail barcode. It would say maybe your internal account number, just random list of numbers, and then your name and address. And they held that that was a violation. So for a good 6 months, we went back and we found hundreds of violations. So we try and get our clients to save their envelopes. It's very difficult.
Tell me
It's
about
hard
it.
enough, right? It's hard enough to save any letter, let alone the envelope. But the more sophisticated ones, or the ones that like to listen, they end up saving it and they send it to us as well.
Okay. Attempting to collect an amount not authorized by the agreement, creating the debt or permitted by law.
Perfect. So F1, I'm actually going to court tomorrow morning on that part of the violation. We have a case against AFNI. They're collecting for AT&T. So obviously they're not allowed to collect any amount unless you actually owe it, or unless the agreement says you owe it. So if the agreement doesn't say you owe interest and they're charging interest, that's a violation, unless your state law allows them to charge interest. So we see that all the time, but more common is we see like these additional incidental fees added. So something like a convenience fee or a processing fee. So, hey, if you call in and pay with a credit card, we'll charge you $4.95. Or to pay by phone, we're going to charge you $5. Or if you want to do a payment plan, that's fine, but there's going to be an extra $2 per payment added on. All of those are fees that I could say with almost certainty the underlying agreement does not allow for a debt collector to charge. So we see a lot of those violations. I'm trying to think. Convenience fee, processing fee, partial payment. I'm not sure if you've seen any other fees, but those are the type of fees we see that would be a violation of 1692 F1.
Yeah, honestly, I don't think I've ever really focused on the fees before. Again, after this conversation, I'm going to make up a cheat sheet so that every time we go through a collection, I'm going to teach my clients how to go through their letters as they receive them to make sure that everything's compliant.
Right, and it's usually on the letter, but on occasion, a client will go on the website to make a payment, and they'll find that after they put the information in that there's a fee being added. That would be a good case, or over the phone, something like that. So your clients should not be charged any amount in addition to what they allegedly owe. And if any amounts are being charged, interest, anything like that, that the agreement doesn't allow, that would be a violation.
In that scenario, if a client was going online and they were charged a credit card processing fee or convenience fee, you would tell them to complete the transaction so they have the evidence, right? Or does it matter?
No, I never tell clients to do that. Obviously, if they complete the transaction, we'd have a better case. But I would never advise a client to just pay something to have a case.
Okay.
I think they have a case either way. The statute's clear and the case law is clear that the violation is not whether you paid the fee, it's whether the collection agency has attempted to charge the fee. And that's all you need. Okay.
Failing to accurately notify the consumer of his or her dispute rights in the initial communication. Is that the Miranda you referred to?
So that's the 1692G. I'll go over the 5 things again. So 1692G says that the collector has to state the amount that's owed. It's 1. It has to state the name of the current creditor. So they could tell you the original creditor. They have no obligation of doing it in the first letter. And then they have to do 3 statements. 1, unless you, the consumer, notify us that you dispute the debt, we will assume it's valid. They mess up that statement a lot by either adding in the word in writing, unless you notify us in writing. It's unless you notify us within 30 days of receipt of this letter. Sometimes they leave out of receipt of this letter, and it's just within 30 days. And obviously 30 days of the date of the letter is a shorter period than 30 days of receipt. So that's statement 1. Statement 2 and 3, they have to tell you has to be in writing. So, and if you do so in writing, we will send you validation of the debt or a judgment. There, if they leave out the word in writing, those words, that would be a violation. And the same with the last statement. If you notify us in writing, we'll tell you the name of the original creditor. If they leave out in writing, that would be a violation. And I'd be happy to send you after this talk a letter that we found recently in which they screwed up all three statements. So they messed up on all three of them, and it's a good way of just kind of comparing or seeing common violations.
Yeah, please, that'd be awesome. Question regarding the Dunning letter.
Mm-hmm.
Now, the collection agency is required to send it out when they first acquire the debt, correct?
A collection agency is required to send it out within 5 days of the first communication. So they can take on a debt and do nothing with it for 2 years and not send you anything. But as soon as a communication is triggered, either by you calling them or if they want to voluntarily send it to you, within 5 days of that, they have to send you that validation notice.
Now, reporting it on your credit report would be a type of communication, wouldn't it?
No. So reporting it on your credit report is a collection activity, and they have to comply with the FDCPA, but the courts have held that that's not a communication, so it doesn't trigger that Dunning letter. So there are companies, I think IC Systems does it a lot, PRA does a lot now, where they'll credit report before they send you anything. It's not triggering that validation notice. But if you see it on your credit report and you dispute it, or you call them up, then that would trigger it. And then if they don't send you a letter within 5 days of that, they'd be in violation of the law.
But so the interesting thing to me is, I mean, if they're not required to send it certified mail to prove that you received it, what's to prevent any of them from just putting it on your credit report and, just saying that they sent the Dunning letter when you request validation?
Well, again, just putting it on your credit report does not trigger that requirement, unfortunately. But you're asking me what's preventing them from not doing what they're required to do and then just lying about it in court?
Right.
Well, that could always happen. It's hard to prove in the negative.
Right.
So if you ever want to come with a case and say, I never received a letter, it's easy for them to just fabricate and say, yeah, here's the letter we sent you, change the date on top. It makes things difficult. It's true. But we find the bigger agencies typically will not risk lying. They'll pay you out. It's a nuisance value for them. PRA is making billions of dollars, so to pay you $5,000 or whatever it is, it's not that big of a deal.
Okay. Right, I understand. Okay, so for people listening, if they believe they are, obviously we're going to put together, I'm going to put together a cheat sheet so that when they receive collection notices that they have a kind of a checklist to compare it against so they can spot violations. But for people in general, if they believe their rights are being violated, what are the steps they should take in order to, document and protect their rights?
Right. So obviously, you want to save all communications, voicemails. If you can't record legally or you don't know how to record, try and jot down how the conversation went with the debt collector. And as soon as you can, send it to an attorney who knows what they're doing, someone you trust. And they'll assist you in the next step. And if you have enough for a case, they should file it pretty soon thereafter.
Okay, so just a question of documenting everything and then getting a hold of you when they think they have enough.
Yeah, FDCPA is pretty simple. It's not like the FCRA where there's additional steps needed, where disputes are needed, and the way you dispute it matters. FDCPA is what you may call a strict liability statute, which means that once they mess up, they mess up. That's the end of it. It's also not a law in which you get money per violation. So if somebody sends you a letter that has 3 violations and they call you up and they mess up 2 more times, unfortunately, you don't get $1,000 per violation. For every case, you only get $1,000. So you're not looking to build the case up or find more violations. Once you find one, that's all you need.
Okay. We focused a lot on FDCPA. Is there anything, is TCPA as you have a common list as well for them?
Sure. Yeah, TCPA is a little bit easier to understand. Last point on FDCPA, I know we never got up to it, is, and I'm mentioning $1,000 now. So what the law says is that every consumer is entitled to up to $1,000 for the violation if they have actual damage. So if they paid something they shouldn't have paid, if they got fired, if they were stressed out and you could prove it, then they could get additional money. But the limit's really limited up to $1,000. And like I said earlier, the debt collector will have to pay all the attorney's fees. So attorneys will just keep their hours in the case. At the end of the case, they'll send that to the debt collector and get paid on that. When it comes to TCPA, it's a lot more technical, but the idea behind it is pretty simple. If you're getting annoying robocalls or pre-recorded calls or things like that, you may have a case under the TCPA. The way you could tell if a call is coming from a machine, obviously if it's pre-recorded, you don't need anything else. It's clearly a machine. But if you answer and there's that 1 or 2 second pause in between the time you answer, someone gets on the other end, it's a good indication. If there's a click, you'll hear a click. That's a good indication. If you're getting calls the same time every day, or every Wednesday at 12 o'clock you get a call, or every day at 2 o'clock you get a call, those are all good indications they're coming from a machine. But obviously, if you're getting calls from a big company like Chase or American Express or any big company like that, nobody's manually dialing your phone number. They're using a machine.
Right.
So you have that part. Now, if it's a wrong number, call. So if you get a new phone number, or someone from Chase is calling you never had a Chase account, or they're saying they're asking for someone who's not you, those are the best cases. They're the easiest cases because clearly you never gave them consent. So if we have a client who's getting wrong number calls, we don't need a lot more than that. We'll subpoena their phone records. We'll find out exactly how many calls we're dealing with. We'll sue. Those usually settle pretty quickly. If we're dealing with a client who had a relationship with the caller, we always advise them to revoke consent. And a lot of times clients come to us and say, I told them not to call, or I told them. We sue. We find out when we get the recordings that that never happened. Or they said something like, it's annoying that you're calling me. That's not enough for the court. You need to be clear that you want the calls to stop. So we usually advise our clients to write them a letter, and we'll help them out with the template if they want. And just be clear. I don't want these calls anymore. Or if I ever gave you consent, stop calling. And if we get new clients, sometimes we'll tell them, as soon as you sign up for a new credit card or a mortgage or anything like that, if you don't want calls, write them from day one. If I ever gave you consent to call me, I'm revoking that consent. Or to call me with a machine. And then anytime down the line, if they end up getting calls, they have a copy of the letter they sent out, and you have a good case.
Okay. I didn't mean to cut you off. Is there anything else you want to cover on the TCPA?
No, nothing else. Just to get an idea, like I said earlier, how big the cases are. Our biggest individual case, which means not a class action, is we got a client $300,000 for 600 calls. We had one client who had a unique phone number, and he's made he's won over $1 million from these calls because he keeps getting wrong number calls.
Damn, I'm gonna buy a freaking unique number.
Yeah, so we don't tell our clients to buy unique numbers. We just get lucky with him. He was complaining to a lot of attorneys over the years. He was getting these calls, and they didn't know what to do. And he ended up finding us, fortunately for us and him. And we went back, we looked at his phone records, and it was insane. He was getting hundreds of calls every month. So we sued all those companies. And then we also sue as class actions. So we had a case against iHeartMedia, who sent out a spam text, and they ended up settling for $8.5 million. It's spread out between the class. So it's a good law. It's a very consumer-friendly law. Unfortunately, on the other end, I wouldn't say they're getting smart, but the new administration is making it more difficult for consumers with these laws, in that they're allowing certain dialers, certain software, certain machines are using to not be considered a machine under the law, and therefore they can call you hundreds of times without any risk of liability. What they call it is human intervention. So if there's any human in between the call, the machine, and you getting the call, any human contact, then it's not a violation or it's not a machine. So the example I give is there's an old Simpsons episode where Homer was working from home and all he had to do all day was press one button on his keyboard, and he had that bird that would go up and down and hit the button. And that's essentially what they're doing. They're hiring people from out of the country, and all they do all day is press a button. And that's all they do. And as long as they have to press a button in order for the call to go through, the court said that that's human intervention and therefore not a violation. So unfortunately, we're losing a lot of these cases now, but there's still time if you're getting calls from big companies to talk to an attorney and see if you have a case.
Okay. All right. So yeah, I was going to open it up to question and answer. I actually wanted to bring up that one I was talking to you about earlier that I mentioned earlier.
Sure.
So I had an account with Verizon. They had some type of billing issue, billing error. They sent me a letter saying, hey, we've been billing you incorrectly. Your monthly bill is going to increase by like $15 a month.
Mm-hmm.
No fault of your own. If you want to cancel now, we'll waive your early cancellation fee. So I called and I canceled. Apparently they didn't mark my account with the early termination. They're still hitting me for the early termination fee. I sent them a letter to remind them, and I even filed a BBB report after a bunch of phone calls. Still getting phone calls. So I sent them a certified letter saying not to call me with the copy of the BBB complaint where they acknowledge that they waived the fee and that they're not going to continue with collection efforts. It got there today. So my question is, how long from the time they receive it? How is it like instantaneous that they're supposed to stop calling?
Yes.
Or is there some time frame?
Yeah. I mean, again, you're going to get $500 to $1,500 per call. So you need a decent amount of calls for it to be worthwhile.
Right.
So yes, any call after that's in violation, but you're clearly not going to file a case in federal court and spend $500 for filing fees if you only got one call, where the most you're going to make is $1,500.
Right.
So yes, any call after they got that letter would be a violation. That's the answer. But in order for it to be worthwhile for you to sue, you need a chunk of calls, a decent amount of calls.
A few months. They're calling like 2 or 3 times a day. So today there was 2. Usually it's 2 to 3 times a day. So we wait a few months. See what happens.
So that's right. You need to wait long enough for it to be worthwhile.
Okay. I see we have a question here. Let me see what we got. Can I get a recording of the webinar? Yes, you can get a recording of the webinar. The recording will be emailed out, after the whole thing compiles and that type of thing. Any other questions? So timing was good. Let's give them a minute before we shut it down. But
I don't know if that's a good thing or a bad thing.
Yeah, no. I thought it was a great interview. I mean, I'm walking away with a lot of stuff that I'm going to be putting this into effect immediately. Will you email us a cheat sheet, Robin? I will. Yes, Robin, you're getting the cheat sheet. Any other questions? You are welcome. Okay. All right, I'm not seeing anything else come up. Actually, there was one question that was emailed to me. I guess he didn't show up, but before I let you go, let me hit you with this one last one.
Sure.
So a creditor or a collection agency files suit. They get a judgment. So now they have the judgment on the client's credit report, but they're still showing the collection open with a balance. Can they have both at the same time?
Okay, so there's a judgment that's being listed as a public record, which